With so many examples of destructive policy and legislation facing South African businesses, South African citizens, South African communities across the board, it's difficult to know where to look on any given day. But one of the organizations really focusing on pushing back, especially through South Africa's court system, is Sakeliga. And joining us to discuss two of their recent court cases, so one that we've had a decision on, one that will be moving through the pipeline and coming up very soon, to detail some of the context behind these two and also what South African businesses and citizens can do to get involved wherever possible. We are joined by Director and Chief Economist at Sakeliga, Mr. Russell Lamberti. Russell, thank you very much for your time. Lots going on. We're recording on the 29th of August. I can't believe we're almost through 2025. We've got things happening on a global stage, a global scene, but of course in South Africa we have very many things happening on the policy and legislation side. So Russell, just to start us off with, we're going to start with one particular case that Sakeliga has been involved in. We did cover this in our most recent risk alert at the CRA, where Sakeliga secured a significant legal victory in the Pretoria High Court, which ruled that the Air Service Licensing Council's use of BEE or race-based criteria in its decision-making was unlawful. Russell, I just want to ask you a bit about where things stand in that particular case, what we're looking at in terms of next steps. Is this now the end of what you guys have identified as third wave BEE?
Chris, thank you. That's a great introduction. It's lovely to be with you. Always a pleasure to talk to you guys. This is a fantastic victory for us. It's only, however, the start of a much broader process in pushing back against what we call the third wave of BEE, which is a very pernicious extension of the existing BEE framework. We like to think of the first wave as being the kind of voluntary empowerment deals of the 1990s. Wave two is really the statutory phase of BEE that begins around the early 2000s with the BEE Act and the various procurement regulations. And that has really been the sort of prevalent, form of BEE over the last 20 or so years. And that has always primarily regulated businesses transacting with the state. The third wave is an extension for the state to insert itself with BEE requirements into business-to-business transactions. There are two current primary mechanisms through which the state is doing this. Number one, using the Competition Commission to regulate corporate transactions and enforce racial criteria on corporate transactions. The second one, which pertains to this particular case, is the state looking to extend the scope of licensing and then of business licensing, and then attaching BEE to that business licensing. And so what we've seen with the Air Services Licensing Council is really, frankly, intimidation tactics when air services businesses, and that includes not just passenger, but crop spraying, game capture, precious metals transporting, any service that takes place in the air falls under this kind of area. And we saw the Air Services Licensing Council really engaging in outright intimidation tactics when businesses were coming to apply for their license renewals, which is about regulating safety. We can talk about whether safety licenses are required in the first place, but the fact is there's a licensing regime around safety. Air Services Licensing Council was seeking to intimidate companies to pursue BEE requirements to get those licenses approved. We've taken that to court, and there's an emphatic judgment that is expressly unlawful. The Licensing Council may not invoke elements of the BEE Act to apply to licenses. It's a very strong judgment that we got. It's not only freed up air services businesses in their license applications, but it has important reach to other sectors where we are seeing the same kind of intimidation. So it's a strong victory in what we call this pushback against what we call third wave BEE.
Russell, I don't want to bore either us or or our audience, but not to get into too much of the legalese. But so in this particular instance, if this now sets any kind of precedent, can this then be applied in other sectors to other licensing councils? Do you think this gives businesses who are looking for, look, they're concerned about, and they have to deal with pernicious policy on a daily basis. They want to push back where possible through things like, supporting the work that Sakeliga does, NIASA, and others. Can one court case in one sector then be applied to others, or at least the judgment?
Yes. So not necessarily automatically, but the precedent is very strong, and it can and should embolden further legal challenges where businesses are encountering this. Now, what we've essentially, I think, dealt with in this case is the case of really quite unsophisticated intimidation tactics that happen at certain regulatory among certain regulatory bodies in this country. There are more sophisticated regulators who look to craft written regulations, or to amend legislation so that they can actually empower themselves to act in these kinds of ways. And so, people just need to think of South African law and regulation in a kind of a hierarchy. There's regulations, there's legislation, and then the kind of bedrock is the Constitution. And you kind of test these things against the more fundamental layer. You test in law, you test regulation against is it empowered by legislation? If it is that legislation constitutional? So that's the process. What we've done in this particular instance is shown the court, and the court has agreed that there is just no empowering legislation to enable this kind of behavior. And that prevails in many sectors where you will get attempted intimidation and invoking of the BE Act unlawfully, as it's been determined by the court, to start intimidating businesses. So I think this is an important judgment, can certainly be applied and used and built upon in similar cases. And this is part of building momentum against this kind of behavior. Some regulators understand this already. And for example, in the financial services sector, there's a huge push, which is a licensed sector. There's a huge push to start tying licensing to various race-based requirements. But there's been some intimidation there as well, which we've pushed back on, and that's kind of been somewhat resolved, pre-litigation. But that doesn't stop the fact that what they are indeed trying to do there is, through the COFI bill, which they want to make the COFI Act, the Conduct of Financial Institutions Act, is actually amend the legislation to enable this. And so that must be not only opposed, but if passed, would then need to be challenged at a more fundamental and kind of constitutional level, and that will require more resources and a larger litigation effort, which is so this victory is very strong. It's very good. It's a good marker in the sand that regulators cannot intimidate and invoke so-called the law to actually force companies into BE in many instances. And so I think this is strong. I think it's going to apply in several places, but it really constitutes just the start of a bigger fight. But we should take wins when and where we can. And this does constitute a bit of a landmark judgment in the sense that it is the first legal rollback of what we call the third wave of BE. It's the first victory, the first legal victory against what we call the third wave of BE. These are tentacles that threaten to really strangle economic activity, must be pushed back against, and this is a good win.
I think in the broader context of sort of more competitive South African politics, when we've seen the building up of especially things like patronage networks and cadre networks and influence, if you look at just under how much pressure the ANC is, and probably still, will continue to be into next local government elections, next national elections, the pressure from the US, I think there's the possibility that there will be incentive to pursue retaining control through things like third wave BEE and this kind of influence and this control. So I think you're exactly right to highlight how important this is and how it should be used going forward. Russell, just a last question on the specific case. So if we go to the judgment and talking about the on the Air Services Licensing Act of 1990, so that piece of legislation specified that licenses must be granted when applicants meet safety, residency, and aircraft control and registration requirements, and that the Act prohibits the licensing council from imposing additional conditions such as BEE compliance. So do you think there's also a bit of, I don't want to say there's an opportunity for licensing councils and regulators to say, like, look, if you guys have your house in order, this case gives you the kind of precedent to say there can't be additional compliance requirements such as BEE. So make sure that you are being as responsible, being as, engaged with your members, making sure that things are made on a commercial basis, on a, safety basis, not on these additional requirements. Do you think there's anything in there to sort of preempt any cases, even though I think that's always going to come in any case? So
yeah, look, there's I guess it's a good point, and I think there's a few sort of there's a few questions in your comment there. So let me just kind of say some high level things. I think that I think people need to understand that these sorts of fights are actually, in a sense, not just about BEE. Maybe not even at the core they're about BEE, although BEE currently represents a very significant component. Chris, what they are about is licensing, socialist business licensing, and attaching irrelevant requirements to licensing for the purpose of economic control by the state. That is what's going on here. BEE happens to be the sort of the front door through which they want to attempt to do that. And one of the reasons is because they believe they can hang a whole lot of kind of moral and ethical weight onto that sort of approach. But really, I think the bigger principle at play here is we've got to limit the state's ability to extend the scope of business licensing. We actually already did that, by the way, during the lockdowns. There were attempts by then Minister Ibrahim Patel to dramatically extend licensing across this economy. This is the goal. If you go back to Soviet systems and various communist countries, they're just a labyrinth of licensing, and it's a completely kind of licensed and state bureaucratized regime where a bureaucrat can insert themselves into process, into decisions, can block, can channel resources into various directions, and so on. And so this is actually the bigger, in a sense, the bigger fight that's at play. And so I think as we look across industries, industry bodies, members of industry bodies, that is businesses, need to be very, very alert to this issue. If you're in a licensed sector, you've got to be absolutely vigilant. This is coming for you. The state is going to try and use BEE requirements, attach them to your licenses, and start denying businesses the right to operate and to exist based on their race. Where else have we seen this? We've seen this in the property industry. Very aggressively in 2024, denying licenses on the basis of race. We were able to reverse that pre-litigation through legal threats, but ongoing work there to strike down certain problematic provisions in the Property Practitioners Act. So this is coming for licensed sectors. If your sector is not licensed, you need to be vigilant that the state does not get a foothold in trying to license your sector, so that your very operation as a business comes down to the say-so of a bureaucrat, which then can be added to with various conditions. So this is really, really key. This is, in a sense, quite a central fight for how the state is trying to control economic activity generally. So I hope this emboldens not only the air services industry, but other sectors where there is no enabling powers for this kind of regulation. People need to push back. People could, in a sense, even, I think, take this judgment, even if it's not pertaining to their sector, where there's similarity. They can show other regulators, look, this is a strong judgment, and be careful what you try and do in our sector, because we're going to take you on. I think that sense of confidence and perhaps even combativeness in the face of this kind of meddling, I think is healthy and important.
Oh, we really need to shift the broader balance of forces, I think, and this could be one of those significant ways to do it in a very positive direction. Russell, moving on to an upcoming engagement by Sakeliga on the NHI Act. So just this past week, so as I mentioned, we're recording on the 29th of August, but this past week, Sakeliga issued an application with the Pretoria High Court to overturn the NHI Act. If you could sort of detail for us what is the main thrust for Sakeliga against the NHI. There are, of course, other applications, other court cases brought by various organizations in the pipeline. So if we could get from you, just from Sakeliga's point of view specifically, what is the thrust here, and perhaps also, timeline wise, what are the expectations around when this could actually, when does the rubber hit the road?
Yeah, thanks, Chris. This is a big one, which I'll try and summarize very briefly, because it's probably a whole separate conversation in itself. But our litigation is comprehensive. It forms part of several other court applications from that are also capable and strong applications from Solidarity, from the Hospital Association, from the medical aids, medical practitioners representative groups. So this is a real kind of all stakeholder sort of pushback against the NHI. Sakeliga believed that while it's very important to consider hospital groups, it's very important to consider medical aids, it's very important to consider patients who are the users of healthcare, and medical practitioners, of course. There is also a business of medicine and healthcare. There's a supply chain, there's a capital structure related to the production and the provision of healthcare services. Everything that is supplied in this massive industry constitutes very, very important business interests, constitutes capital that's at risk and that's invested for return. So there's a major supply chain in this, and Sakeliga, in a sense, has kind of spoken to and in a sense representing that broad medical kind of business sphere. Because we think the NHI is incredibly destructive, has the potential to do immense harm, not just to the healthcare sector. That's fairly clear and obvious that a type of nationalization of healthcare is going to be really disastrous. The abolishing of private medical schemes, essentially monopolizing, having the state as the monopoly so-called insurer, but really just payer of healthcare. This is going to lead to a dysfunctional healthcare system. We've spoken about health shedding, or even more macabre, you might talk about life shedding in a similar way that we've seen load shedding. This is really the kind of direction that this goes in. The case itself makes very compelling arguments against the simple viability and affordability of such a system, which speaks to the unreasonableness of the measures, the irrationality of the measures, Chris. So that's our case. There is certainly going to be some overlap with all the cases. I think that having numerous strong cases representing different interest groups and different stakeholders is a good thing. I think it's an all of stakeholder, all of society approach, if you like, to push back against the nationalization of healthcare in this country. I think that's necessary. How the court deals with that in terms of consolidating cases or hearing them one by one, these are technical decisions that are going to kind of unfold over really months. The NHI itself is something that's being very gradually implemented. Really, there's no budget allocation for it at this stage. So this is a kind of long fight, but it's an important one. All the key stakeholders that are required to make this thing work are opposing it. Okay, so and that's a good thing. So I think that this is a prolonged process. People shouldn't expect decisions in the near term. There's the first types of decisions that are going to be made is simply how to hear these cases. And that's going to take, I think, a long time. I think we're probably going to be looking at maybe in 26 and then rolling forward for several years. I think this is a prolonged fight.
We often talk about what unites South Africans, and many people try and find, throughout, I guess, the union of South Africa, the sort of centralized state that is South Africa, people have been looking for things. If one of those is going to be into the next maybe 100 years, sort of different stakeholders and civil society pushing back against destructive and pernicious state overreach, I think that might be one of those to hang one's hat on in terms of uniting South Africans across the board. I can think of worse things to unite South Africans. So Russell, I think to you guys and to Sakeliga, thanks very much for that work. Just a last maybe note from you in terms of others getting involved, other businesses with these, not directly with the court cases, but maybe supporting Sakeliga to South African citizens who follow all these developments and want to support. Anything from your side? Any specific call to action?
Yeah, thanks, Chris. Look, it's very easy to get behind Sakeliga, sakeliga.org.za. We have a funding page there. We are funded by South African businesses, from small sole proprietors, micro enterprises, all the way up to large businesses. They back Sakeliga's mission. If you like what we're doing, we need funding to do that and to scale up our litigation strategies against these very harmful and pernicious policies. So getting behind Sakeliga, and then, of course, if you like what we're doing, also spreading that message and growing that network. We are a business community, and pooling the capital of good, ethical businesses into a focused strategy to tackle some of these major problems and these pernicious threats at scale. That's what Sakeliga offers the business community, and so getting behind us in that way is very valuable to us.
That's a very good note on which to end. Russell, thank you once again very much for your time with us this week. To all of you, thanks very much for watching. A last note: if you found this discussion and analysis useful and you are not yet a CRA premium client, we invite you to become a client. You can find more information at the link below. Get in touch with us today to get access to all of our reports, briefings, and analysis. Thank you all for watching, and we'll talk to you all again very soon. This has been Chris Hattingh for the Center for Risk Analysis.